Welcome to a bite-sized HIPAA Q&A video where we answer your questions about how HIPAA applies to your dental practice. We recently received the following question in our bite-sized HIPAA Q&A inbox. The writer says, "We asked our practice management software provider to sign our business associate agreement, but they refused and said they will only sign their own BAA. Since it's our patient's PHI, we feel like they should have to sign our agreement. What should we do?" Well, thanks for submitting this question. This is a very common practice with larger vendors and providers. And in this video, I'll help to explain why that is and what your practice needs to be looking for in third-party BAAs. First, let's see what the HIPAA law has to say about whether business associates can require you to use their BAA instead of your own. There are 3 sections in HIPAA that lay the groundwork for the requirements surrounding business associate agreements. Let's break down what these sections mean for your situation. First, Section 164.308B1 states that covered entities, you, can share PHI with a business associate only if you obtain satisfactory assurances that they will appropriately safeguard that information. And then second, in Section 164.314A2IA, it says that these satisfactory assurances must be documented in a contract that requires the business associate to comply with all of the applicable HIPAA requirements. And then finally, in Section 164.504E, we see that it further details the specific required provisions for BAAs, including, but not limited to, specifying the permitted and required uses of PHI by the business associate, requiring the business associate to use appropriate safeguards, and ensuring that the business associate reports any security incident or breach of PHI to the covered entity. These sections make it clear that while having a business associate agreement is a must according to the law, the specifics of what that agreement looks like aren't really set in stone beyond the basic requirements that just assure the vendor will take good care of patient PHI. This means clear rules on how PHI is used, shared, and protected, plus what to do if there's a breach or someone gets unauthorized access. If the vendor's BAA covers all of these bases, then you're in the clear as far as HIPAA goes. In order to provide some additional context on this question, let's approach it from a slightly different angle. Let's ask why certain vendors would refuse to sign your BAA. Well, while BAAs are written chiefly to protect patient data, BAAs are also written to protect the organization writing the agreement. Attorneys tailor these agreements to protect their clients from the liability that's associated with protecting patient data. Or more specifically, what happens when those protections fail and who's on the hook to make it right. That's why BAAs often address things like liability, indemnification, and insurance requirements. For example, our bite-sized HIPAA business associate agreement template makes it clear that if a business associate causes a breach, they are responsible for paying to clean it up. Plus, they need to have a robust safety net in place, a minimum of $1 million in cyber liability insurance. But now imagine a vendor working with hundreds or thousands of individual dental practices, all wanting them to sign their custom BAA. Well, the vendor would need a team of attorneys to review each unique agreement and also a comprehensive system to keep track of the nuances in each one of those signed agreements. The scope of this compliance process is impractical for vendors to manage, pushing them to insist on a standardized business associate agreement that then they can build in their internal policies and procedures around. So even though you will likely be required to accept some vendors' standard BAA, don't be too quick to sign it. Be on the lookout for language that protects the vendor from liability and risk caused by their actions. Review every BAA carefully. Highlight any language that limits the vendor's liability, and then discuss that with your attorney before signing. To summarize, Business associate agreements between covered entities and vendors with access to patient health information are required by law. Who writes the BAA doesn't really matter, so long as the contract provides a solid, HIPAA-compliant plan for protecting the patient information that you share with them, and that it meets any specific requirements you have, such as assigning liability in the event of a breach. Remember, it's the substance of the agreement that counts, not whose logo is on the header. Assume that vendors' BAAs were written to protect their own interests and not yours, so be aware of those risks so that you can make a good business decision. Sometimes liability is addressed separately in your service agreement with the vendor, so check there too. And as always, have an attorney review these agreements before signing. And remember, HIPAA requires you to keep a copy of these executed business associate agreements for 6 years after termination of the agreement. So make sure you keep a signed copy of every BAA in a safe place. If you have a HIPAA question related to the day-to-day operations of your dental practice, feel free to send it my way. My email address is todd@bitesizehipaa.com. That's 1 P and 2 A's. I can't promise I'll be able to get to every question submitted, but I'll do my best to find the most applicable ones to address in future Bite Size HIPAA Q&As.